I think as people are joining here, I just want to welcome everybody to the Carroll Center's Estate Planning and Special Needs Trust webinar. My name is Dara Delmata. I'm the Chief Development Officer Chief Development and Communications Officer at the Carroll Center for the Blind. We're thrilled to offer this informational webinar that will explain the different components of an estate plan and the various types of special needs trusts. We will have time for questions at the end. So please submit your questions in the chat as we go throughout the webinar. And we also are recording this webinar. So we will send out a copy as soon as we have that ready for you, likely tomorrow. So in case you miss anything or want to watch it again or share it, you will have the ability to do so. So now, without further ado, I would love to introduce our speakers. Eileen Lee Breger is an attorney at Bowditch and Dewey. Eileen concentrates her practice on estate planning, tax strategies, special needs planning, estate and trust administration. With her special needs planning practice, Eileen assists those who want to leave assets to a beneficiary who may have a disability. Through the planning, she establishes special needs trusts that provide for the beneficiary's lifetime needs while allowing continued access to government assistance. Prior to joining Bowditch and Dewey, Eileen practiced at Metro West Estate Planning Law Firm. And after Eileen, we will hear from Joan McGrath. Joan is the Chief Executive Officer at Plan of Massachusetts and Rhode Island. Joan has been with Plan since 2009, and prior to assuming the role of CEO in February 2020, Joan was Director of Finance and Administrator for Plan and has more than 25 years of experience in professional accounting and finance. She's been an auditor with the Big Four public accounting firm, where she focused on high-growth emergency and business clients. She also led her own private consulting practice, where she worked with nonprofits, service organizations, and venture capital startups. Joan earned a bachelor's degree in accounting from Boston University's School of Business. Joan is a member of the Boston Estate Planning Council, the Estate Planning Council of Rhode Island, Academy of Special Needs Planners, Alliance of Pooled Trusts, and National Plan, and is on the board of Best Buddies Advisory Board. So thank you both, Eileen and Joan, for your time and insights today. And I also wanted to just thank both of your organizations for your partnership with and support of the Carroll Center. Bowditch and Dewey has supported our Walk for Independence, and Plan of Mass and Rhode Island is our exclusive trust partner and also supports the Walk for Independence, as well as the Technology Fair and alumni and parent programs, which are Carroll alumni and Carroll families. So without further ado, I'd like to introduce Eileen, and she's going to start us off with an overview of the estate plan. Eileen?
Thank you, Dara, and a big thanks to the Carroll Center for the Blind for letting me present once again with Plan of Massachusetts and Rhode Island on estate planning and special needs trusts. I'll be going through an overview of what a core estate plan looks like and speaking about how a family might use a special needs trust in their estate plan to provide for a disabled beneficiary. Every adult should have a core estate plan, which typically consists of a will, revocable trust, durable power of attorney, healthcare proxy, HIPAA release, and medical directive. Oftentimes I'm asked why people use a revocable trust. It's often because people want to avoid probate. A revocable trust, in many cases, is a substitute for a will. So like a will, it can contain dispositive provisions for how your assets are distributed. Unlike a will, a revocable trust is a private family document. It's not submitted to the probate court. And anything that is funded to a revocable trust or names the revocable trust as a beneficiary does not pass through a probate process when the person who sets up the trust passes away. A durable power of attorney names someone to act on your behalf in legal and financial affairs. This can be for convenience, but more importantly, it's oftentimes used if someone becomes incapacitated. A healthcare proxy allows you to name a healthcare agent to make medical decisions for you if you're unable to make them for yourself. And then there are two companion documents to the healthcare proxy, and that's a HIPAA release, which gives authorization to your doctors and healthcare providers to talk to your loved ones about your care. This is particularly important if you want a spouse, children, or grandchildren to be able to participate in your medical treatment. And last but not least, many people do have a medical directive, also known as a living will, which expresses end-of-life wishes about treatment options. Many people have a medical directive that's based on quality of life. It usually will say that if you are suffering from a severe illness or disease and there is no meaningful expectation, there's no reasonable expectation of regaining a meaningful quality of life, you do not wish for your death to be postponed. You don't want aggressive measures to be taken, in other words. So many people do sign that type of statement to provide guidance to their family members and healthcare agents. For those of you who might have children under 18 in a will, you would name a guardian for your children should you and your spouse pass away before they reach 18. If you have an adult disabled child, you can name a guardian for that child in your will. Many parents who have disabled children are serving as guardian. And you want to make sure there's continuity, for your child. You don't want to create conflict between different sides of the family. So as part of your estate plan, in your will, you can name a guardian for an adult disabled child. A big part of estate planning is naming those individuals or professionals who will serve as fiduciaries in your plan, the executor of your estate, trustee, and attorney in fact. That's the person who holds authority under a power of attorney. And, oftentimes my discussions are, with families about who they're going to designate. Are they going to designate one child? Will they designate multiple children? Will they name individuals or will they name professionals like an attorney, like a CPA? For a trustee of a special needs trust, a nonprofit pooled trust like Plan of Massachusetts and Rhode Island can serve as a professional trustee. Joan will talk a little bit more about that. A fiduciary is a person or entity with the power and obligation to act for another under circumstances that require total trust, good faith, and honesty. So it's very important to think about who you're going to name. I once had a client tell me that she trusted a family member 95%. And in all honesty, after we talked about it, she decided in the end to name someone else, a professional as fiduciary to serve as trustee. It's really important that you name someone who you trust implicitly. Most people have, a natural person that they'll name a spouse or a child. If you have more than one child, you'll have to think about whether you name one at a time or name all of your children together. And people have different views. Sometimes families want to name all of their children because they want them to all be involved, checks and balances. It's more democratic. But when you do have multiple people named, you want to make sure that they get along and they can make decisions together. If that's not the case, then, it may be a good idea to just name one person, one decision maker can really streamline the process. The purpose of estate planning is to provide for orderly disposition of your assets. You want to ensure a smooth transition at your passing. You don't want your loved ones to be frustrated. It's also to protect your beneficiaries. How will you provide for a beneficiary who's disabled or has special needs? Very likely, if someone has a severe disability, is not able to manage assets, and or is receiving government benefits, you do not want to leave their inheritance directly to them. Instead, you would use a supplemental or special needs trust to protect their eligibility for government benefits. It also will provide lifetime management of the assets for the beneficiary who's disabled. For other beneficiaries who are not disabled, you might still use a trust for creditor and divorce protection. You want to think about the risk that your beneficiary has, again, for lawsuits, whether they're in a marriage that's bad and there's a potential for divorce where the ex-spouse could reach half of the assets that your beneficiary inherits from you. There are ways to protect the assets that you leave to your loved ones by setting up a trust. Another concern you may have for the estate planning is whether your beneficiaries will pay an estate tax. So if a child is receiving a large inheritance, or if the child has a lot of assets of their own, and you don't want their inheritance to be counted towards their taxable estate, you can use a trust to remove assets from their estate for estate tax purposes. With all estate planning strategies, there are trade-offs, and it's important to sit down with your attorney or advisor and just kind of go over the pros and cons of different approaches. The other purpose of estate planning is really to ensure that your plan is implemented properly. So when I work with clients, it's a two-step process. The first step is preparing the documents and coming up with the plan of distribution. That's step number one. And then step number two is making sure that your assets and beneficiary designations are consistent with your estate plan. You want to make sure the titling of your assets will flow to your trust if you have a trust, or to the beneficiaries named under your trust. So it's very important to do that second step in the estate planning. Everything I've mentioned today about the goals of estate planning is not an exhaustive list. I really encourage each individual and family to work with a trusted advisor to come up with a plan that's tailored to their needs and priorities. It's important to have an attorney or advisor who really knows you and your family, and who will be there in a time of need, a time of crisis, whether it's incapacity event or at your passing. To illustrate the estate planning concepts here, I have an example. Mark and Jane, they're in their 60s, and they have 3 adult children, 2 sons and 1 daughter, Cece, who is disabled, and she's receiving mass health benefits because of her disability. They have assets that they want to leave to all 3 of their children, including Cece, and they do not want her inheritance from them to disrupt her access to public entitlements. Mass health is very valuable. They also want to make sure that there is a structure in place to ensure the lifetime management of property for Cece. So they will have a revocable trust. During Mark and Jane's lifetime, they serve as the initial trustees, and they're the lifetime beneficiaries of the trust. But when both of them pass away, the trust says that the trust property is divided into equal shares for their children. They've decided that their sons will receive their respective shares outright, but Cece's share will be paid to a special needs trust. The question for them, though, is what kind of special needs trust? They can set up a trust in their estate plan where they name family members to serve as trustees, and they will write the terms of the trust. Or they could name a poll trust, a nonprofit organization like Plan of Massachusetts and Rhode Island, to receive CC's assets and be a professional trustee. So a lot of families are, have to grapple with this issue. So even though siblings can serve as trustees for a special needs trust, families may not choose to name them because it's a huge responsibility. They may feel that they don't want to burden their other children, with this, and instead they want to name a professional trustee like Plan of Rhode Island and Massachusetts. It's professional management, and there's a whole team, at Plan that, can really, that services the trust. They have social workers on staff, and they know how to manage the trust. So that's an option for Mark and Jane. If they did not feel that their, sons should be trustees, they could name Plan of Massachusetts and Rhode Island to be the trustee. So there are different types of special needs trust. So the type of trust that Mark and Jane are setting up is a third-party trust. So I'll actually jump ahead here. It's a third-party trust because it's funded by their assets. Third-party trusts are usually set up by a parent or grandparent for the beneficiary. And the key benefit, of a third-party trust is that there is no payback provision to Mass Health Medicaid when the beneficiary passes away. And third-party trusts are in contrast to first-party trusts, which typically are used in situations where there's an unexpected benefit to a disabled beneficiary on public entitlements. A special needs trust is set up by the assets of by the disabled beneficiary if they have capacity using their own assets. So this could happen if Mark and Jane, let's say they did not set up a special needs trust for CC in their estate plan. Maybe they didn't get good advice and they just left her share outright to them, but she's on public benefits. If she receives her share outright, that disrupts her benefits because she'll have more than $2,000 in assets. So in that case, if CC has capacity, she can set up a first-party trust and fund her inheritance to the trust, and those assets in the first-party trust will not be countable. Other situations where first-party special needs trust might be used are if a disabled beneficiary receives a personal injury settlement, or if they receive an inheritance unexpectedly. Sometimes aunts and uncles will leave $100,000, $200,000 to a disabled niece or nephew, and they don't set up a special needs trust. In that case, a first-party trust could be used for the disabled beneficiary. So keep in mind, first-party trust can only be used by beneficiaries under age 65 without a transfer penalty. For those individuals over 65, there is a new law that has been enacted in Massachusetts. It's actually a reinstatement of the old law that becomes effective December 6th, that allows transfers by those over 65 to a first-party trust, as long as it's a poll trust, like Plan of Rhode Island, Massachusetts. And I know Joan will go into this in more detail. The big difference with a first-party trust and a third-party trust is that in a first-party trust, there is a payback provision to Medicaid when the disabled beneficiary passes away. So it's better if mom and dad are doing estate planning to set up a third-party trust. Oftentimes, a first-party trust can be sometimes we'll call it an uh-oh trust because it's done after someone inherits assets unexpectedly and they're trying to protect them, after the fact. Mhm. Mhm. So who is a special needs trust for? It's just because someone is disabled, doesn't mean that they need a special needs trust. I have clients who are blind and they work and earn a living. They may not need a special needs trust. It's really for someone who has a severe disability, who's not able to earn a living, who's on government benefits or has the potential to receive government benefits. So for every family, every individual who's doing an estate plan, they have to evaluate whether the beneficiary really needs a special needs trust. I work with a number of families who have adult children that are bipolar. And the big question is whether we use a special needs trust or not. It's hard because many people who are bipolar are high functioning. They hold down jobs, but that can change over time. I'm working with a family right now who their son, while he was able to work before, is no longer able to work. And, they're thinking about updating their estate plan to include a special needs trust for him, to protect his assets. How does a special needs trust work? And why is it non-countable for public benefits? So a special needs trust is not considered a resource of the disabled person who is receiving or applying for government benefits because they do not have control over the assets. Instead, a trustee is named who has sole discretion to make and apply distributions for the benefit of the disabled individual. So in Mark and Jane's estate plan, because CC never has control of the assets, she's not trustee, nor can she remove and appoint a trustee. The assets in the trust will not be count if for purposes of government benefits eligibility, but she'll still be able to benefit from the trust because the trustees can pay for her any needs that are not covered by benefits. So Mark and Jane, this is great for them because they do have significant assets and they want CC to receive, a third of the value of their house, as well as a third of their estate, which is about 500,000 in securities and retirement accounts. All of that can be held in the special needs trust for CC's benefit. Although, these assets are greater than the 2,000 asset limit for Medicaid Mass Health, the assets of the special needs trust will not be countable because they are not controlled by CC. So she'll continue to receive Mass Health benefits while having a trust to pay for her needs. So with a special needs trust, the trustee oftentimes will pay for a beneficiary's needs. Distributions usually are not made directly to the beneficiary. So if a beneficiary needs something, could be a mortgage payment. It could be further education, travel. The trustee would just pay the third party directly for, on behalf of the beneficiary. Now, while government benefits covers a great deal, it doesn't cover everything. So the idea of a special needs trust is to pay for things not covered by government programs: travel, education, caregiving, supplemental care, and medical services not provided for Mass Health. So a trustee can also, if the trust is drafted properly, a trustee can use the trust assets to provide for something that government benefits would provide for if it's in the best interest of the trustee. So, for example, so even if CC received housing benefits, the trustee might say, well, it's actually in her better interest if she owns a house or she owns an apartment. The trust could own the house, own the apartment. She wants to live in the town she grew up in. So the special needs trust could buy a home for CC. The trust could own the home, and the trustee would make important decisions such as selling the home or making improvements to the house. So that allows, for a management structure. Now, keep in mind that the trust should hold other assets besides real estate. It is difficult for for a trust like this to get a loan. It either has to have its own assets, besides the house. So just keep in mind, besides real estate, other assets should be funded to the trust. And again, the trustee can decide to use the assets of the trust, even if they displace government benefits. It's really in the discretion of the trustee and what's best for the beneficiary. So sometimes trustees will use the trust to pay for private health insurance, even if a beneficiary qualifies for Medicaid Mass Health, because some private insurance options might have better choices. Many trustees will work with an attorney to administer the trust. Every trustee of a special needs trust should be familiar with the basic rules of public benefits. Certain distributions by a special needs trust can affect a beneficiary's eligibility. For example, distributions of cash or in-kind distributions for housing and food by a special needs trust can reduce or eliminate SSI benefits. So there are certain provisions that are included in special needs trusts. Oftentimes you see an independent trustee requirement, though it's not strictly necessary. It's best practice to name an independent trustee, someone who doesn't have a beneficial interest in the trust, a third party who can be objective. Oftentimes families do name siblings who could be qualify as independent trustees as long as they are not a contingent beneficiary when the disabled sibling passes away. So for Jane and Mark, they do want to name Cece's siblings, Chris and Aaron, as co-trustee of her special needs trust. Upon Cece's death, the way they've structured it, any remaining trust assets will pass to Cece's descendants, if any. And if she doesn't have any, then to descendants of Chris and Aaron. And this is to qualify Chris and Aaron as an independent trustee. So that's one way to structure it. It's important that a special needs trust does not give a disabled beneficiary the right to remove and appoint a successor trustee. Instead, what Mark and Jane can do is name Chris and Aaron, Cece's siblings, to the power to remove and fill a trustee vacancy. And this can be really helpful because at some point, Chris and Aaron may decide to step down as special needs trustee. Maybe it's too much of a responsibility of them and they can appoint a professional trustee to serve instead. And because they have the power to remove and appoint a trustee, if the professional trustee is not working out for some reason, they can appoint someone else, a different professional trustee. And then there usually is a trustee, there should be a trustee exclusion in a special needs trust that says Cece as the disabled beneficiary cannot serve as trustee. And that is to protect, protect the assets of the trust for being countable for public benefits purposes. So that is the end of my part of the presentation. I think we're saving questions probably until the very end. But at this point, I'm just going to turn it over to Joan McGrath of Plan of Rhode Island and Massachusetts. Thank you.
Thank you. So I'm going to apologize in advance. Much of what I will be presenting will be repeating a lot of what Eileen has already mentioned. So I'll start with who Plan is. Hopefully people can see this presentation. So Plan is a 501c3. Dara, are you able to see this?
I can't see it.
You can't see it.
Perhaps maybe reshare. Maybe she hadn't taken hers down yet.
I just unshared my screen.
Mhm. There we go. It's coming up.
Thank you.
Mhm.
You have to go down here. What are you trying to do?
Can you
Okay.
see that?
Perfect. Thank you. You all know who I am. Plan is a 501c3 nonprofit organization. We're actually professional trustees. We provide professional trustee services for special needs trusts. That's our focus. That's all we do. We work with both pooled standalone third party and D4A first party. These are trusts that Eileen has already mentioned. I'm sorry, I'm going to, can you let go of that? Thanks. Okay. So we have over 800 beneficiaries and 80 million in assets under management. We've been doing this for 54 years. We have 10 licensed social workers on staff, and we have special recognition in the Program Operations Manual, or the POMS, as MARC Special Needs Pool Trust, that were specifically noted in the Social Security Administration's POMS. And I'll speak a little bit more about the POMS as we go along. So our mission, we proudly serve people with all types of disabilities, whether due to illness, injury, or age, helping to preserve assets, protect access to public benefits, and to help people live well. Quality of life is really important with a special needs trust. So what is a special needs trust? And Eileen again spoke something about this. It's a special needs trust or supplemental needs trust. It's a legal document enabling assets to be held on behalf of someone with disabilities without affecting their eligibility for means-tested benefits. A beneficiary will keep their benefits and still be able to access their special needs trust. We're going to talk a little bit about the types of trusts, but the first party or the third party, which really are the important things to keep in mind. So why do we need a special needs trust? Proper planning for the future creates peace of mind. It enables the beneficiary to preserve their public benefits, supplement their needs, and have the means to improve their quality of life. And when we say supplement their needs, that's the benefits provide for the needs, but then there's always that extra that someone needs to have that life to be comfortable. So I usually give an example of a wheelchair. Medicaid allows for a pad for that wheelchair once every 5 years, where your trust can be used to replace it how often you need it. For people that are over 65, there's a lot of things that come up that they find that they truly need. So an example would be someone in a nursing home and they've left their dentures on the bed, the sheets are changed, the dentures are gone, then special needs trust can be used to replace those. A special needs trust is really important in helping to improve family relationships. So if we think about the brother and sister that Eileen spoke about, the brother may not want to ask the sister or I'm sorry, the other way around. The sister may not want to ask her brothers for needs that she wants to be paid. It can cause friction. It can cause, the brothers may not understand what it is that she needs and why she's looking for that to happen. They may be concerned about impacting benefits, so they don't want to disperse something, or they are dispersing everything that she asks for, not realizing that it's impacting her benefits. So you really have to understand the disbursements that you're making. So who might benefit from a special needs trust? An individual with a disability who seeks or wants to maintain public benefits. Family members concerned about the well-being of a disabled person, and it really does shift that fiduciary responsibility to the trustee. People with whose disability impair their ability to manage money. Types of trusts. So there's, and this is again, Eileen spoke about this, but there's a third-party standalone trust. which is generally more flexible. And it's an arrangement, an attorney would draw up this document for one person. There are very few POMs relative to the third-party special needs trust, and most importantly, there's no Medicaid payback. So this is really the type of trust that you want to make sure that you get set up. Self-settled D4A first-party trust, and the last slide I referred to it as a supplemental needs trust. So a disabled person's assets are used to fund the trust, which could be an unplanned inheritance, lawsuit, court-ordered support, to benefit the disabled individual 64 and under. So there is a Medicaid payback. So one of the things that when we say unplanned inheritance, there's a grandmother and she's got 5 grandchildren, one of which is blind. And but the person also does qualify for a special needs trust. So the grandmother leaves the money, and now the money is in the hands of the child that is considered disabled. That will impact their benefits unless they put it into a first-party trust. So types of trust continued, pooled trust. So plan administers the standalone third party, the D4A first party, and the pooled D4C. Most of the people that are with us are in that pooled D4C trust. The difference is this is a master trust, and there are many people that join this trust. In the pool trust, you can be either a first party or a third party. So if you have smaller dollars, you don't meet the minimums of some other institutions that could be a professional trustee, you can always go to a pool trust. So funds are pooled for investment purposes only, and that's important to know. If you join a pool trust, you have your own account. It's your money goes in, your money goes out, money that's earned in interest, gains, losses, everything is contained into your sub account, your own individual account. It's only pooled for investment purposes. And then federal regulation requires that a nonprofit, as Eileen said, be the professional trustee for a pool. So again, trustee responsibility. So this is trustee responsibilities for any kind of trust, be it a professional trustee or any trustee. So you have to ensure the trust is used for the sole benefit of the individual, so benefits are protected. That is very, very important. Regular contact with the beneficiary and or power of attorney. You cannot take money into a trust and then never have connection with the individual. There's a large bank, I forget what year it was. They basically just took fees out of that special needs trust. They did not have contact with the beneficiary. They were sued and had to replenish the money back to that trust. You are responsible for overseeing accounting, investments, tax preparation, and reporting to the appropriate government agencies. You need to understand public benefits. You really do need to understand, as Eileen mentioned, housing, the rules for housing, and the rules for Medicaid, and understanding and following the POMS, the Program Operations Manual. So trust administration considerations. So you need to, is the trustee knowledgeable and skilled regarding special needs trust regulations? Will the trustee be able to serve the life of the trust? So you want to find a professional trustee that is going to be here in 20 years, 30 years. You need to make sure that, I don't know the age of the beneficiary, but that the organization is going to be around. Benefits of a professional trustee versus a family trustee. Timely processing of disbursements, accountings, and tax reporting, final accounting, and communications with Medicaid estate recovery, ability to pay for services and items that enhance the person's quality of life, and preserving family relationships. So I'm sort of repeating myself here. With the special needs pool trust, it should be ongoing reduced costs compared with traditional costs, traditional trusts. So establishing a special needs trust with plan. You could do that by going to our website and completing an application. We do have online applications for first-party trusts, third-party trusts, and pooled first-party trusts, third-party trusts. A plan assigns a service coordinator who works with the beneficiary to develop a spending plan. So once the trust is set up and it's funded, a service coordinator who is a licensed social worker will reach out and talk to both the donor of the funds. So let's assume this is a third-party trust. They'll speak to the donor of the funds to learn what the intention is for that money. Maybe the donor wants it to be spent on education for the beneficiary, or the care of that person. So I had a mother call me once and said, when I'm gone, who's going to make sure that my son's toenails are trimmed? Who's going to make sure that they're living in a clean environment? That's where we come in. So with the social workers on staff, they go out and they meet with the beneficiary and they learn what they're interested in, how the money can be used to benefit their life, quality of life. Do they want to go on vacation? Do they want to, buy a bike? Do they want to take swim lessons? These are all things that come into the plan. So again, if it's a third-party trust, the donor sets up, they can do a letter of intent, but often we have them fill out what's called a life care plan, and they complete that document and let us know how they want the money to be spent. And then we work with the beneficiary to make sure that they are taking advantage of things that are open to them without impacting their public benefits. Plan is a trust department with the trust officer and staff that review disbursements on a weekly basis. Funds are invested in an appropriate investment strategy. Plan has 7 investment strategies that we work with, and we use the person's age, their disability, where the money is to be spent, what the intention is, what their needs are, what their needs are within the next year. And all of these are come into play when we put together a strategy. Those strategies are reviewed annually, and all of the money is held at Webster Private Bank. And we work with Webster Private Bank to make sure that we're getting a proper return on investment for each person at whatever strategy they're at. Most importantly, plan has no minimums, where if you were to go to a bank or somewhere else, you may need to have $500 to $1 million or more. Plan has no minimums. We do, however, suggest that you have at least $10,000 to begin with. Again, plan is unique in that we have social work support. As I mentioned, these are licensed social workers who work with the beneficiary. They're their primary liaison. They help them work. They provide guidance on how to use the trust funds to better their lives, to meet their needs, to supplement their needs. And they are experienced with all types of disabilities. So scenarios where special needs trust makes sense with plan, families who do not want to place responsibility on the siblings. We get calls from the parents have passed and now the sibling is the trustee, and they will call and they will say, I can't handle this. I don't know what I'm doing. I'm taking a job. I'm moving to California and I can't do this. I love my brother, but I can't do this. So that's where it'll be given to us. So we're the successor trustee. So these are conversations that should have happened before the parents passed, but we understand it gives peace of mind to the family. So if someone has inheritances or legal settlements, life insurance proceeds or gifts, they can go into this special needs trust to prevent that interruption of benefits. And having smaller assets that may not satisfy the minimum deposit requirement at other institutions, as I mentioned, are perfect for a pool. I'm kind of repeating myself here. So tax forms are prepared and forwarded to beneficiary power of attorney, and those are used. The plan, the professional trustee should be filing the 1041. So plan does that. we work with Ernst & Young. So we take the information that the person may have had a gain during the year. You know, the market's been volatile and their holding may have had a gain, you know, when maybe something was cashed out or, you know, so all of that information is bridged over to Ernst & Young, and they prepare the 1041 tax return for the trust. And then they prepare tax documents that would be filed with a person's individual personal 1040. If there's any tax that would be due on that 1040, they would send it back to the trust, and the trust would cover those, would cover the tax if anything is due. Most people that we have in the trust don't pay taxes. Examples of way to fund a special needs trust. So as I mentioned, for a third party, it could be life insurance, inheritances, inherited IRAs. So it would be inherited retirement benefits. So a parent is working and they've listed the third party special needs trust as the beneficiary of their retirement account. And that's actually where most people's money is. It's in retirement accounts. I'll speak a little bit more about that on another slide. And then the first party settlements, unexpected inheritances, and personal injury settlements. So there's an accident that happens, you can't plan for that. And that's how the first party comes along. The person now needs care. They need to maybe go into a facility, or they need to, you know, if they're over a certain age, they're going into a nursing home. So it could be anything that happens where the person needs now to go into a nursing home, they can't show more than $2,000. That money can go into a first party trust. So what are the tax considerations of naming a third party special needs trust as the beneficiary of your IRA or qualified retirement plan? Plan, the organization I work for, is a qualified retirement account. By naming Plan, the third party special needs trust, as beneficiary of your IRA or qualified retirement account, and this would be Plan third party special needs trust for the benefit of your loved one's name. That would be held by us. There is no tax consequence for that because it rolls over into this account. That account then would take the required minimum distribution annually and put it into the third party account for your loved one. So if the by doing that, there's something that passed recently, the Secure Act, and the Secure Act allows the taxation of those trust retirement funds to be spread out over the life of the beneficiary. So we can talk about this. This would be something that you want to talk to your attorney about, but knowing that you can, we're one of the few actually trusts that you can do this with, where you can have it come to us and there's no tax consequence. So tools that work together. I'm trying, what time is it? I want to make sure we're leaving enough time for questions. Okay, great. Tools that work well together. People often ask, and I think I saw a question pop up about the ABLE accounts. The ABLE accounts and special needs trusts work really well together. They complement each other. So here's just a table to discuss, you know, when you compare them. Special needs trusts are established by a beneficiary or his or her parent, guardian, or agent. There is no age restriction for a special needs trust. And flexibility in funding. So there's no limit to the amount of money that you can put into a special needs trust. So when I say there's no age restriction, as I mentioned to you, you cannot set up a special needs trust if you're 65 and over without putting it into a pooled special needs trust. It has to be pooled for 65 and over, but you can still set a trust up. If you were to try and set up a special needs trust 65 and over without it being part of this pooled, you'd be subject to a transfer penalty. And the law has been in place for 30 years that you're able to do this. In March, they reversed it and you weren't allowed to, but now they've reversed it again and you are allowed to set up a special needs trust for 65 and over. So, but the point here is for when you're comparing it to ABLE is there's flexibility in funding. And there's no limit, the amount of money that you can put into a special needs trust. There's no Medicaid payback for a third-party trust, and there's a payback only for the first-party trust. So again, if you're doing your planning, which you are doing just by being here, you set up that third-party trust, and you can avoid that Medicaid payback. It can supplement, it can pay for supplemental expenses and improve the quality of life of the person. It's professional investment of funds, and it's placed in appropriate strategies. Now compare it to an ABLE account. It can be established by a beneficiary, his or her parent, guardian, or agent, exactly the same as the special needs trust. However, there are restrictions in age. The person can't set up an ABLE account. You cannot set up an ABLE account unless you've been diagnosed with a disability prior to the age of 26. That is going up to 46 in 2026. There is a maximum of $100,000 that can be put into an ABLE account. At that point, if you're on SSI benefits, your benefits will be suspended. There is a Medicaid clawback for all ABLE accounts. And that simply means that from the date that you set up that ABLE account until the person passes, Medicaid has the right to pull that money back and get paid first. So it can only be used for qualified disability expenses. But this does include shelter expenses for SSI recipients. And there is tax-free growth if funds are used for qualified disability expenses. So they work really, really well. So a special needs trust can take money from the special needs trust and deposit it into the ABLE account. And then the person can use that ABLE account, and they really gain a sense of autonomy and control of their own funds. And they can use that ABLE card to purchase items. The special needs trust has something called, we use a TrueLink card, and a TrueLink card can also be used to make purchases, but it is subject to the same rules that govern a special needs trust. So planned giving is one of the things that, when you set up a special needs trust, as I mentioned, the donor can dictate where the funds will ultimately go. So the funds can be used while the beneficiary is alive for certain purposes, and it can be used to quality of life. It can be used any number of things to supplement needs, but a third-party trust, it can be used for quite a few things. So when the person passes, and if there's any money left over, the donor has dictated where the funds ultimately will go. So part of planned giving is that you can decide you want to leave some money to the Carroll Center, or you can leave some money to the Carroll Center and to the siblings of the beneficiary, or you can leave them to grandchildren or whoever you decide you want to leave them to. So it's really important to consider that when you're doing your planning. And that's my presentation. I'm sorry if some of it was repetitive, but if you have any questions or if I can clarify more, please give us a call. We don't charge for consultation. We're happy to help. If you need referrals to other organizations, we're happy to provide those as well. But, think of us if you need a special needs trust. Oh, Craig has joined us.
Great. Well, thank you so much, Eileen and Joan, and we have quite a few questions, so I'm going to get right into it. Some have, I believe you've addressed them. I'll start with a few that were asked around the cost and how trustees get paid. So I think one of the questions was the approximate cost of setting one up. I believe, Joan, we've covered that. With plan, there's no minimum starting cost. You do recommend $10,000.
Sure. But
so-
the cost to enroll is, if it's a third-party trust, it's $500. That's the cost to have review the application and to submit it all to our attorney to make sure that we can do that.
Okay. So that enrollment cost, but then
I think that's what they were asking.
Okay.
about. Yeah.
Perfect. And then there's questions around how the trustee gets paid. For example, how does plan get paid for your services? Do you take a percentage of the assets annually?
we do take a percentage of the assets annually. So if it's comes out quarterly, and because our fee is 3%, but it's at a certain point it reduces. So when you get to a certain dollar amount, so but that percentage fee covers the social work, the trust administration, and the investment of funds. And if I compare that to a bank, you would pay 1.25% for the investment of funds, and you would pay, you don't get that social services piece. And I'm not sure what the cost of the trust administration would be, but maybe it's all rolled into one. Or if you went to an attorney, you'd pay trustee fees, whatever those fees are. But then if you needed social services, you would have to pay for those separately, which would be, $125, $150 an hour, or the investment of funds on top of the attorney fees, and that could be 1.25%. So it sounds like a lot for us, but when you compare it, break it down, you can see, which actually people have asked me to put together a slide to show that breakdown, but I haven't done it. So it's what you need. If you want that social work piece after you pass to work with your child, then we might be the person to reach out to. We would be the all-inclusive cost. Hopefully I answered that question.
And if I could add a
Yeah.
little bit, Dara, to that question about trustee fees. So trustees of a special needs trust are entitled to reasonable compensation. So if a sibling is serving as trustee, they may elect not to take a fee. That's a possibility. But it is a big responsibility, and it's a lot of time spent administering the trust. And so sibling can be paid for serving as trustee. That those costs and fees would be paid by the trust itself. If an attorney is serving as a trustee of a special needs trust, it could be hourly, or it could be a percentage of assets under management if the attorney is with a firm that also does the investment management. And then so in that case, it's a little more similar to plan, with a percentage of assets under management based on the amount. It's a sliding scale, just depending on how much money is being managed. But that's just what I wanted to add about trustee fees.
Okay, great. Next question. If the parent of an adult disabled child has not officially become their legal guardian, can they name a guardian of their adult child in their special needs trust?
Yeah, so the parent doesn't have to be guardian to name a guardian for their adult special needs trust. Special needs child. There are so the guardian nomination would be in mom or dad's will. And they could, so if the child currently doesn't have a guardian, mom and dad, can name a guardian. If the child has a guardian right now, currently, mom and dad, or the intent would be to name a successor guardian if that person couldn't serve. Right. So a lot of time, I work with families that have, mom and dad, they have a special needs child, but child's currently not under guardianship. Even though they have a disability, but I still have mom or dad name a guardian just in case circumstances change in the future.
Okay, great. The next one is about the age cutoff for ABLE accounts. The first question was strictly around that, what is the cutoff age? And if I'm understanding correctly, you must be diagnosed with a disability before the age of 26 at the current time, but that's going up to 46 in 2026. Is that, did I recap that correctly? Okay.
Yeah.
And the next question, for someone who with an acquired disability after the cutoff age for an ABLE account, is a first party special needs trust a good option for those individuals to self-fund the trust with savings they may have acquired while they were able to work?
Yeah, you can't put income into a first party trust, but you can put savings. So you could fund a first party trust.
Okay, perfect. And then the next question is, what about someone who develops dementia and becomes mentally disabled? Can a special needs trust be applicable for them?
Yes. Yeah. So that would begin, you work with your attorney to figure out. So I'm thinking dementia, they're over the age of 65. So that would have to be a pool trust,
Mhm.
and that would be a first party pool trust.
Yeah. So hopefully, this person who's developed dementia has a power of attorney. And the power of attorney document, typically has certain powers that are given to the agent, authorizations. So if the transfer, if the power of attorney is just has made a decision on behalf of the person with dementia to transfer excess assets to a pooled first party special needs trust, plan would be an option, and I imagine plan would want to review the power of attorney document to make sure that whoever is acting on behalf of the elder, has the authority to do that. Yeah, no, it can't be done, but it's probably, if someone's developed dementia, it has to be done either under power of attorney or through a court order under conservatorship.
And next question is, what happens to the trust if the disabled person passes away before the parents/guardians?
So if it's a third party trust, the person who set up the trust tells us where the money goes. If the person passes away and it's a first party trust, Medicaid gets the first right to those remaining funds. So again, plan the third party trust. That is the way to do it. So did I answer the question?
I believe so. To me, that it sounds like that you did. I guess someone can post another question if not.
So in the estate planning, mom and dad can set contingencies. So if the disabled child, God forbid, passes away prior to mom and dad's death, usually it says, usually it goes to that child's children, if any, and if not, then it's added to the shares for the sibling.
Then can the special needs beneficiary receive a cash allowance?
So you can't give cash to a beneficiary. It would impact their benefits. So what we do is someone can use their credit card, and we would then pay their credit card. So we can pay a third party vendor for that person, but we can't give cash to the beneficiary.
Okay. And then someone had a question around, it sounds like parents would set up a third party trust. When they set up that trust, does that mean all of the assets, including homes of the parents, are now owned by the parents, are not owned by the parents, but are owned by the trust? Or does the trust start upon the parent's death?
So we have something called a future funded trust, third party trust. So a parent would work with Eileen, set up the plan in place, and then upon their death, it would fund the third party trust, and whatever assets they wanted to go into that trust would happen upon their death. And we strongly recommend that people set up these future funded trusts so that it's in place. So God forbid they both die in a car accident, the money then can go directly into the trust and it doesn't impact the person's benefits.
Mhm, mhm. Yeah, for many families, the special needs trust is funded after parents have passed away to hold the child's inheritance. So, but that's not always the case. There are, lifetime trusts that are set up for gifting purposes. Families who have taxable estates, may want to make gifts to a special needs trust during their life to ensure assets, are protected. That's usually a conversation that's in the context of tax planning. But for most families, if they're just most families, I would say, at least the ones I work with, are setting this up for after, after they've passed to be funded at their death. Mhm.
Great. And then a clarifying question, Medicaid can take money from the ABLE account only upon the disabled person's death. Is that correct?
I don't know the answer to that. For payback, Medicaid payback of an ABLE account, I would think would be when they ended the ABLE account or they passed away. But I don't know that for sure. That would be probably a question for Fidelity. I think they're
Yeah, Fidelity.
Yeah.
The custodian of the ABLE. I mean, that's my understanding that the payback or clawback happens after the death of the disabled beneficiary, but yes, that's really dependent on the plan, the ABLE account documents, which would be through Fidelity or other institution.
right.
Great. Can a person diagnosed with a congenital condition such as autism later in life use an ABLE account?
They'd have to be diagnosed before the age of 26, or they'd have, again, 46 in 2026. We work a lot with autistic people, and this is actually a way that parents gain comfort by setting up this third-party trust. It gives them that they've planned. So I think that might be their only option.
Okay.
You shouldn't say that, Eileen. Actually, do they have other options? I'm very focused on special needs trusts.
Mhm.
Well, I think that question was specific about ABLE accounts, was it there? Yeah, ABLE
Yeah,
accounts,
ABLE.
there is that age restriction. Yeah, I mean, most of what I see are third party planning. It's mom and dad setting up the supplemental needs trust, for a child. Could be a grandparent setting up the trust, sometimes an aunt or uncle, a family member or a loved one. Yeah, it's rare that I see, I mean, yeah, it's more rare that I see someone, setting up their own, first party trust just to hold assets. Mhm.
Yeah, you wouldn't do that, no. So with the ABLE account, it's $18,000 a year. That's not a great deal of money that you would put into an ABLE account.
Oh, true.
It's the gift tax amount that can go into the ABLE account.
Mhm.
Um,
Right,
the-
it's limited, 18,000 per
Right.
year.
Actually, if you're working, you can put more money
Mhm.
into it. So where I said the special needs trust can't accept income. However, so if you're working, you wouldn't put your income into the special needs trust to avoid the $2,000 limit. But with ABLE, you can put that in. I think it's up to whatever I want to say $26,000 or something around that, that you can put in additional into your ABLE account if you're working.
You're working.
So there is definitely flexibility, and ABLE's a great thing to have, but with the age restrictions, it's limited.
Okay, I wanted, I guess, two questions. One clarifying question, is what you said that once a trust is set up, beneficiary listed on the assets would be third-party special needs trust, so that all assets got to the trust?
Are you asking me? I'm confused by the question, so.
Yeah,
So if you
that,
set up a trust with plan.
yeah, once
you-
this trust is set up. the
Well, you decide
beneficiary-
what it's gonna be before you set the trust up. Is it a first party or a third party? So you
Ah.
fill out whatever application. It's a third party trust is what we should all be focusing on at this point. Because the whole purpose of this is to plan. So it would, let's just say it's a third party trust.
Mhm.
So once the third party trust is set up and funded, social workers would go out, the spending plan would be done, prepared, and then all the decisions related to strategies and everything would be made at that point. I don't know if Eileen has something to add to that about setting up that third party trust.
Not sure I completely understood the question, but third party trusts are funded by the assets of someone other than the disabled beneficiary. So just to be clear, it's
Mhm.
usually parent, grandparent, family member. And yes, once the trust is in place, the assets have to be used for the benefit.
Okay, yeah, and I think that does
disabled
answer the
person.
question. I think they were asking to clarify, was that third party that you were mentioning, was it third party that gets, so I think you're confirming what they were asking. So then one last question, if a parent, third party, creates a special needs trust to their child, what happens if the child inherits from the grandparent? Does the child need to create the first party special needs trust to move over the grandparents' unexpected inheritance?
Yeah,
Yeah.
it could be that there are two trust accounts, a third party trust account and a first party
Mhm.
trust account for the.
So when you,
Mhm.
oh, I'm sorry. So when you set up that third party account, you need to tell people, you need to tell your parents and your siblings and anybody you think that might be leaving money to your child that this trust exists, because the language has to be there. It's like your life insurance. It has to say the third party special needs trust for the benefit of the child. If it doesn't, unfortunately, it then becomes a first party trust. The language has to be there.
And just a word of caution here, if, this is all for planning, if mom and dad are anticipating contributions from other donors like a grandparent, they should let their estate planning attorney know, because we will, we'll have a conversation. There should be, the trust can be drafted in a certain way to anticipate that, it's, anytime you have a trust with multiple donors, you just want to make sure you're thinking through the implications. So please let your attorney know. But yeah, there are situations where mom and dad set up the trust and they let other family members know about the trust and they give the name of the trust. And then, when grandma's naming the beneficiary on her IRA, she'll put the name, third party trust, third parties, special needs trust for the benefit of, and then, it'll go into that trust.
Yeah, it's just sharing
In the future.
information.
Yeah,
And-
it really is coordinating, and it's
Yeah.
so important to coordinate, it's, work, when you're working with an attorney, working with plan, let them know what you're thinking. Because, part of the planning process is to just understand what your goals are, how how the trust will be used. And we can make sure that we're structuring everything around that.
Okay, great. We do have two more questions, but they're going to be better answered, I think, in a post-webinar email. There's just questions around a list of qualified attorneys that might be taking clients, and also some written information on types of trusts and plans available. So that information we can share following the webinar. Like I mentioned, we will share the recording. And we'll share Eileen and Joan's information. So any questions you have directly for them after, you can direct to them. So thank you very much for your time. And we really appreciate your time today. And thank you very much. We will be in touch with that information later this week.
Take care.
Thank you.
Thank you.
Bye.
Bye.